Ready where you are, Francesca.
Okay, so good afternoon, everyone. My name is Francesca Capone, and I'm currently Associate Professor of International Law at Scuola Superiore Sant'Anna. I would like to start by thanking Professor Martinico and Professor Delle Donne, because they are obviously the heart and souls and mind behind the 𝗥𝗨'𝘀 and the 𝗥𝗨'𝘀 seminars that are a huge success and are well known, not just within the Italian borders, but also beyond. We are here today to officially comment on and launch a very interesting and timely book, which has been authored by Dr. Joyce De Coninck. Joyce, he's a scholar. Currently, she's a Max Weber Fellow at the European University Institute in Florence, where, of course, she has been suffering extremely this heat wave. But there are also a lot of perks in being a Max Weber Fellow, that's for sure. She has been working on this very important topic for several years now. The book's title is The European Union's Human Rights Responsibility Gap, Deconstructing Human Rights Impunity of International Organizations. And Joyce has undertaken, published by Heart Publisher, which is obviously an excellent publishing outlet. So congratulations again to Joyce for these many achievements. And she has been working on this particular issue already during her PhD, which she defended at Ghent University. Also during her postdoctoral fellowship, she has been also a Émile Noël Fellow and a scholar in residence at the New York University School of Law. And she has extensive experience in this particular field, but more broadly also within the international human rights law, European Union law, and migration law. And she has collaborated over the years with many different academic institutions in Europe and beyond. So we are extremely grateful to Joyce for accepting our invitation to present this book. For the sake of completing my round of introduction, I will now move on to our two discussants. They are actually, one of them is actually my colleague, and the other one is a brilliant PhD student at the Scuola. The first one is Professor Lorenzo Gasbarri, who is currently a tenure-track assistant professor of international law at the Scuola, and also the director of a very important and interesting master in electoral policy and administration. Lorenzo has extensive knowledge in the field of the law of international organizations. And just to mention one of his many achievements, he is the author of a very well-known book, which is The Concept of an International Organization in International Law, that has been published in 2021 by Oxford University Press and has been praised worldwide, so much that it has been recently translated also into Chinese. Lorenzo is also the convener of the interest group on international organizations of the European Society of International Law. So he can really bring his very broad and very well-structured perspective into the discussion today, and I'm very grateful for his presence in the panel. The last, but definitely not least, speaker today is our own Sian Donkers. She is, as I said, a PhD candidate at the Scuola. She's enrolled in the program in Human Rights, Global Politics and Sustainability. Her PhD thesis focuses on European Union liability for the restriction of effective access to international protection through the use of integrated border management in the non-European Union Western Balkans. She has been working as a lawyer for several years, focusing in particular on immigration and asylum in the United Kingdom. And before joining us as a PhD candidate, she has earned her LLM from the National 𝗥𝗶𝗴𝗵𝘁𝘀 University of Athens, and also an MPhil in conflict resolution and reconciliation from Trinity College, Dublin. So what we are going to do today is basically to discuss the book that Joyce has written, and we will start by giving the floor to her for her presentation, and we will be grateful if you can keep it within 25 minutes. After that, we will move on to our two discussants to collect their comments and potentially also questions and follow up on the book. And after that, I will gladly open the floor for further questions from our audience. And without further ado, Joyce, you have the floor.
Thank you so much. And first, let me take the opportunity to thank the colleagues at Sant'Anna for the invitation and for the willingness to comment on this book. It's truly an honor. What I'll do with you today in the 25 minutes that I have is I'll give you 4 sets of observations to give you a sense of what the book is about and what I was trying to do with it. But before I do, I try to start every talk about this book with a question to indulge me. So if you will indulge me for just a minute, and please imagine yourself in the middle of the Aegean on an inflatable dinghy with approximately 20 other people that you don't really know. It's the middle of the night. You have just been pushed back violently by individuals that are unidentifiable, who have also taken your cell phone. You have no contact with the real world, with the outside world, with the exception of one plane that hovers over your dinghy throughout the course of the night. By morning, you see a ship come in. You think for a second that you are saved, but instead you realize quite quickly that it's actually the Turkish Bordering Coast Guard, and you're pulled back into Turkey, into a detention center or a reception center that feels like a detention center. And these are essentially the case facts of the 𝗥𝗶𝗴𝗵𝘁𝘀 case, which is pending before the Court of Justice of the European Union in an appeal, where the question that is at stake concerns the liability of Frontex, the European Bordering Coast Guard Agency, for having purportedly flown the plane over the dinghy in the middle of the night, but having not provided any assistance to the 20+ people that were on that inflatable dinghy. So with that in mind, the question arises as to liability for non-state entities, and specifically what I will refer to as EU entities, so EU institutions, bodies, offices, and agencies of the European Union. And that brings me to my first set of observations. The question of human rights liability for non-state actors has been the topic of much scholarship, and it's a particularly salient question for the European Union for a number of reasons. The first being constitutional. We see that the EU, unlike other international organizations, has its own internal constitutional-like catalog of fundamental rights, human rights, by which it is bound. The second reason being regulatory. We see that across different pieces of secondary EU legislation, the European Union legislator has inserted all sorts of provisions, both preambular recital clauses as well as operative provisions in its secondary legislation, which also hold EU entities to abide by human rights. The third being a legitimacy question, namely the European Union through its external relations generally, but also specifically through free trade agreements, for instance, imposes obligations on its collaborating partners abroad to comply with and respect human rights. And then the fourth dimension concerns the remedial dimension. We see that the European Union is built and based on the rule of law, which encompasses the right to an effective remedy. So the question of EU liability for human rights violations becomes particularly prominent in cases such as the EU's integrated border management, where we see that there's been a lot of reporting on potential human rights complicity by EU entities and agencies like Frontex specifically, albeit without any successful cases to date, or any overwhelmingly successful cases to date. So when you think about how to assess human rights liability of EU entities, there's of course a number of ways that one could go about this. One could look at the policy itself, so integrated border management specifically, and try to assess that policy for its compliance with human rights. And a number of scholars have done this, some of whom are Giulia Raimondo, Sara Ganti, and Dimitri Kochnov, Roberta Mongiani. These scholars look specifically at the integrated border management itself and try to identify whether there's issues with respect to human rights compliance issues with respect to the policy. Then you've got other authors such as Melanie Fink, who wrote a groundbreaking piece of work with respect to Frontex specifically. So she looks at the specific agency and the specific procedure of the action for damages to make that same type of assessment. And then there's also the path-breaking work by Violeta Moreno-Lux, who looks at integrated border management more generally, albeit from a state responsibility perspective. And so what I do with this book is slightly different in that I take the harm as a given. So I don't try to establish how or the degree to which these entities contribute to a potential human rights harm. I assume that the harm is there and I work backwards. And I try to see whether an individual, both under international law and EU law, could leverage those regimes to be able to hold the relevant entities legally responsible in a court of law. So, and this through different iterations, and both in theory and in practice. And so in that sense, integrated border management within the context of this book is more of an illustration, but it is a particularly paradigmatic illustration precisely because of what I've said before. We've had since 2015 numerous accounts of potential human rights violations that were contributed to by the EU's IBM policy generally, but Frontex specifically, albeit without any cases yielding any successful outcomes. And of course, in the absence of any successful legal cases, a number of reasons could be at the heart of that. The first being that the European Union simply isn't doing anything wrong. So no violations have actually occurred, meaning that there is no reason for successful outcomes in courts for applicants claiming human rights violations. One could also argue that there's already sufficient accountability, so not responsibility in the legal sense before courts, but that we have enough political accountability. One could also argue, and this is the work by, amongst others, Virginia Pasalacqua, that there's an issue of legal mobilization, that aggrieved individuals are simply not finding their ways to court for all sorts of different reasons. But many of these potential explanatory accounts require understanding of the EU's human rights responsibility regime as such. And that brings me to my second set of observations. What I do in the book is try to construct and understand what the EU's human rights responsibility regime looks like and how it operates in practice. And so before I explain what the EU's human rights responsibility regime is to me, or in this book, two caveats are necessary. This book, first and foremost, is a book about regime interactions. So when assessing the EU's human rights responsibility regime, one cannot look solely and exclusively at EU law. It is almost imperative to also bring in international law, as the European Union as an entity, a supranational entity that was developed first and foremost as an international organization, is invariably connected to international law and bound by international law to different degrees. So while that's one of the hallmarks of the book, it was also one of the biggest obstacles to writing this book, because necessarily, as soon as I adopt EU language in the book, international lawyers would object, and vice versa. As soon as I adopted international law language, EU lawyers would object for different reasons. So a lot of the terminology has been really thought through in the book so as to be able to speak to those different audiences, not to mention the human rights scholars and the asylum, borders, and migration scholars. So although regime interactions is inherent and one of the positive aspects of the book, it's also one of the struggles. The second caveat is that the book is functionally driven, which means that in trying to understand the EU's human rights responsibility gap, I start from the question of how could an individual go to court and be able to leverage these different regimes and their different rules to be able to obtain reparations. So with that, inevitably comes the consequence that I have to understand the languages and adopt a functional lens in trying to understand those languages. So with that in mind, with those two caveats in mind, the EU's human rights responsibility regime, for me, is comprised of two sets of rules across two different legal regimes. So we have on the one hand, the first set of rules, which concerns the human rights norms by which the EU is bound. And those human rights norms, so the right to life, the prohibition of refoulement, the right to liberty, and so forth, can be found both in international law and European Union law. In European Union law, we're looking at the Charter of Fundamental Rights and general principles of EU law. In international law, we're looking at international custom, we're looking at jus cogens, and to the degree that the EU is a treaty signatory party to certain treaties. So the second set of rules that we're looking at are the liability rules, the so-called rules of the game, right? So how do you go to court? Which conditions, according to those two regimes, do need to be met in order to be able to successfully claim that the EU has contributed to a human rights violations? And again, here you see that it's a set of rules that is found both under international law and EU law. Under EU law, we're looking at the action for damages, which is the sole procedure which can yield reparations for human rights harms. And under international law, we're looking at the articles on the responsibility of international organizations. A little anecdote here is that I have run into a number of international law scholars that contest and object to the use of the 𝗘𝗨𝘀𝗀, so the articles on the responsibility of international organizations, because it's not binding, because there's a lot of contestation around their effectiveness and so forth. But given the EU Commission's own contribution to the development of the draft articles of the 𝗘𝗨𝘀𝗀, I felt it imperative to include it in the book nevertheless. So again, what you see is that we have two sets of rules across two different regimes. On the one hand, the human rights rules, or norms rather. On the other hand, the liability rules, and this across international and EU law. And one could wonder, are these rules sufficiently similar to be able to adopt an integrated approach? With human rights, it's very clear that the EU's Charter of Fundamental Rights is mirrored on international human rights law and the common constitutional traditions of EU member states, which in turn are also mirrored on international human rights law. So there's no issue there. And two, the liability rules, and this is where that functional lens really comes in, essentially ask the same thing, even though they adopt different terminology. According to the liability rules, in order to claim responsibility of an EU entity, one would need to show a violation of some sort, causality, attribution, and damage. And so because they're all the same, pretty much the same, I embark in the book on both this doctrinal investigation of whether these regimes yield an effective human rights responsibility regime in theory, as well as an empirically minded investigation of 4 different case studies in integrated border management against which I apply this human rights responsibility regime. And that brings me to the third set of observations, the findings. So even though there's much more in terms of the technicalities of what I find, I'll focus on 2 incongruence clusters. But before I do, incongruence for the purpose of the book means or signals the distinction between, on the one hand, what the rules or the human rights responsibility regime sets out to achieve, and on the other hand, what it can actually achieve in practice. So pointing to the difference or the distinction between the law in the books and the law in practice. And I come to the conclusion that there are 2 main incongruence clusters, the first being normative and the second being a liability incongruence cluster. The normative incongruence cluster points to the distinction between human rights commitments on the one hand and human rights obligations. And now bear with me for a second. Very often when we're talking about human rights, we gloss over what that means and the complexity of what a human rights violation looks like. So for instance, when we're talking about state responsibility, we see that over the course of time, there has been a very significant translation process that has translated human rights commitments as we find them in international treaties, in regional treaties, in custom, etc. We see that these have been translated into actionable, justiciable, enforceable, negative, positive, procedural, and substantive obligations. So in sum, very shortly, we see that human rights commitments have been translated into obligations. And this has fed into consensus, which then informs how, regional courts, for instance, apply these rules in practice. What we have with respect to the European Union and EU entities specifically is that this translation processes by which we translate commitments into obligations that are enforceable and justiciable, that has not meaningfully happened for EU entities. The conclusion of that is that in the absence of concretized obligations to give flesh to the bones of the human rights commitments by which EU entities, in theory, are bound, we can't actually establish if a violation has occurred. And for a long time, I thought I was maybe a little bit going too deep into this, and that I was a bit of a conspiracy theorist, and that I was exaggerating this distinction, until I found myself in court in the 𝗥𝗶𝗴𝗵𝘁𝘀 case, in its appeal, and I was pleading or answering the questions by the bench, and the response of the opposing counsel for Frontex was specifically this point, was that Frontex is not a state and therefore cannot be bound by the same human rights obligations that are positive, negative, procedural, and substantive as can states. And this on account of the functional difference. So the difference between, the EU as a supranational organization on the one hand, and states being sovereign entities under international law on the other hand. So that's the normative incongruence cluster. And the conclusion of that, again, is that if you don't know what the actual obligations are by which EU entities are bound, your first cumulative condition to establish responsibility can never be met. And the second cluster, the liability cluster, is by far the most technical aspect of the book, and counterintuitively, I'll be the shortest about this. Attribution, for the purpose of exhaustiveness, points to, or is the test to be able to identify the correct author and connect that author to a particular line of conduct. Yet what I see when I'm looking into international law as well as EU law is that there's at least 6 different attribution tests that exist that have both a broader and a stricter application. And that means that the courts, without any definitive guidance, and then particularly the Court of Justice specifically, in the absence of any definitive guidance, it's free to adopt whatever test of attribution it wants in any given case without the applicants per se knowing beforehand which test would apply. And I'm thinking, for example, the ultimate normative control test. We have the EU's competence test, where you have a broad and a strict version. You have the test of effective control, and so forth. And so it gets a little bit worse when you realize that the EU necessarily, or EU entities necessarily, interact in operational conduct with member states. And so taking that, what we see happening is that for the same type of harm that an EU entity together with a member state has contributed to can be litigated before different courts. And those different courts for different actors in different jurisdictions with different procedures will adopt different attribution tests, but for the exact same harm. And the implication of that is that all of the complicit actors may effectively be held not responsible for any contributions to the harm because of the application of different attribution tests. And again, here I thought, again, that I was a bit of a conspiracy theorist for a long time, until a case to this effect effectively came out by the Court of Justice, where it held that if we don't fix this attribution problem, we have an issue with respect to the access to an effective remedy. This was the Marian Kochner case of last year. So essentially what you're doing with these 2 normative incongruence clusters is there's an absence of certainty about how these conditions apply to EU entities, specifically when they're in joint conduct. And so it's akin to asking an applicant to land a plane after you put a blindfold on that person. It's possible that they'll be successful, but it's highly unlikely. And so your human rights responsibility gap doesn't just occur because it's hard to hold the EU entity legally responsible because you don't know what obligations they're bound by, but it's additionally hard because there's the risk that for joint operations that implicate both EU entities and member states, also the member states will evade any responsibility, which leaves an applicant without any actor to hold legally responsible. So that brings me with my final set of observations. I don't like sitting back and just diagnosing issues, so I made a humble attempt at trying to provide for an alternative approach, and that brings me to the relationality of human rights responsibility in the EU. And as I was thinking through this, I came across a lot of theories on shared responsibility. The audio provides some insights in this respect. We have the general principles on shared responsibility in international law. And in investigating all of this, I noticed that a lot of different authors were using different terms, ranging from joint to shared to relational. Little did I know that by using the term relational, I was opening Pandora's box. And I noticed that in different disciplines, relationality theories are actually very commonly discussed. And of course, none of these theories have an overarching idea of what relationality as such would do or would mean, but they do share two common features. On the one hand, foregrounding, not surprisingly, the relationship and decentering the individual actors, and on the other hand, unveiling power imbalances. So I embark on this relationality theory in which I think one of the ways forward would be to relationalize EU human rights responsibility. And of course, the inevitable question is then, how does one do this? And so in this respect, I see three immediate ways forward. The first one being regime coordination. And it's, again, not as exotic as one may think. Regime coordination already is happening through judicial dialogue between the Court of Justice, for instance, and the European Court of Human Rights. Another mechanism would be to establish a regime coordinating liability mechanisms. And we see that within the context of data protection and Europol, another EU agency, this has already happened through joint and several liability. Then there's also a regime coordination approach by EU accession to the European Convention of Human Rights. So these are all mechanisms to ensure regime coordination so that you don't have the issues that we have whereby all actors could essentially escape responsibility for contributions to a joint harm. The second set of interventions would be to look at the burden, standard, and method of proof as a way to unveil that power imbalance. And to my surprise, this effectively came before the court, and this was the appeal that I was involved in, where we argued that in order to ensure effective judicial protection and in order to ensure that there was no procedural inequality in the 𝗥𝗶𝗴𝗵𝗁 case, it would be necessary to reverse at least partially the burden of proof so as to ensure the effectiveness of human rights within the EU's legal framework. And then finally, a third set of interventions would look at substantively tailoring the human rights commitments as they apply to EU entities. So in that translation process of translating human rights commitments to obligations, one would need to be aware and cognizant of the fact that EU entities simply don't have the means or the capacity to abide by human rights obligations as do states. And so you would have to look at how you modulate, for instance, substantive positive human rights obligations so that they can effectively be met by EU entities. Does this solve all problems? Of course not. It raises more questions than it solves, because as soon as you agree with the premise of the book that we need to reconfigure the human rights responsibility regime of the EU, you also have to wonder who would design this, and that's the topic of an ongoing paper. But nevertheless, with a flawed system, you have one of two routes to go. You can disavow the system altogether, get rid of it, start anew, or you can try to diagnose what's wrong with the system and try to remedy it from the inside out. And so what I'm trying to do with this book is try to diagnose some of the issues that we have and try to establish human rights responsibility vis-a-vis EU entities, and then try to provide alternative pathways forward to remedy these issues. Thank you very much for your time, and I'm very much looking forward to questions and concerns about the book. Thank you.
Thank you so much, Joyce, for this very, very interesting and precise overview of the theoretical underpinnings of your book, as well as of the main findings. This book is very interesting for many reasons, but what I really like the most is the passion that you have put into it, in the sense that it's not just an effort that is limited to show how well you know the international legal framework as well as European Union law, but also it's an effort, an attempt to propose how to overcome some of the challenges that we are currently facing. And in some instances, they seem impossible to actually be faced in an effective way. But on the other hand, the tripartite way of working that you propose in your book makes perfect sense, also because it uses tools that are already at the disposal, not just of the courts, but also of the European Union entities and of the state. So it's a very proactive approach on how to fill a responsibility gap that we are all very well aware of. And having said that, I will leave the floor first to Lorenzo, whom I'm sure has a lot of things to discuss with you, and after that to Sian, so that she can also jump in and contribute to the discussion. Thank you so much. Lorenzo, you have the floor. Thank you.
Thank you. Thank you so much, Francesca, for the nice introduction and for everything. Thank you, Beppe, for giving me the opportunity to comment on such an interesting book and also to contribute on the discussion. It is triggering. I entirely share the concern that Joyce was mentioning at the beginning on how to merge the two different sides of the same coin, on the scholars that study international organizations and the scholars that study the European Union. There are so many issues to agree. But of course, putting them together in a discussion is extremely difficult. I can see for the terminology, as you rightly pointed out, and so on. So this book achieves something that is very, very difficult to do in this sense. And on a topic that is so important, such as the European Union accountability gap, which of course is European Union accountability gap, but it's also the member state accountability gap. Of course, states like Italy, which is totally integrated in the process, in the system, and with its own responsibility. So distinguishing between the two is an essential task for lawyers that study law today. Of course, especially in the migration context. So Joyce's book is a valuable addition to the already extensive bibliography on this topic, as she mentions at the beginning. And again, what I think is the main characteristic that makes this book standing out is the intended aim of comparing or discussing, integrating international responsibility and the European Union institutional mechanisms. And really the capacities of jumping from one regime to the other is really exceptional. And I totally also agree with this approach and with the need to jump from within, from outside, but not only for the European Union, but also for other international organizations, which we don't, we still have to think about that accountability gap also applies in other contexts, of course, when we discuss the law of international organizations. It may remain one of the essential elements that is not applied, but in which the law of international organizations really has very little to say, or is it really completely unable to tackle these problems, which I think is also based on the a lack of theoretical discussions of what international organizations are. And maybe I can contribute on that also, what I would like to say in this 15 minutes. So, yeah, I would like to make, there is really a lot to discuss. I will make 3 main points that I would like to do, which I think are essential to understand the problems and how deep the problems are concerning the EU accountability gap. So first, I would like to comment on your employment choice of the concept of lex specialis. So which is the tool that you use to jump from EU to international responsibility, EU extra-contractual damage claim, and what is lex specialis and how I interpret lex specialis as such. And then I would like to discuss a bit on primary obligations, So your point also on the distinctions between commitment and obligations. And finally, something about shared responsibility. So more or less, I would like to tackle all your main points of what you discussed before. And let me start to take advantage of the time. Concerning 𝗥𝗡𝗀𝗀𝗃, so exactly, you use this as a tool. The tool that you, if I understand correctly, is what you use by claiming that there is lex generalis, which is represented by the area, contested, okay, but this is, I perfectly agree that we cannot discuss international responsibility of international organizations without deep confrontations with the rules developed in the area. Also for the role of international organizations, of course, in developing it, in the European Commissions in particular. And there is 𝗥𝗡𝗀𝗀𝗃, which is, as you claim, if I understand correctly, is also represented by the rules of the organization, which is somehow derives from the reading of the area itself in Article 64, which is the approach which is really pushed forward by the European Commissions and others and several other international organizations, under which, if I understand it, the rules of each international organizations will be able to contract out from the rules for the international regimes of responsibility. Okay, is the institutional rules of each organizations will be able to contract out from international responsibility, which of course is an easy way out to the importance of the area as such. And many will say, well, put this article, not Article 64, but Article 1, because that's the main regime, and then maybe if there are gaps and so on, the lex generalis would apply. So I think this poses a serious threat to any possibility of establishing an accountability mechanism for international organizations based in international law. And I also think that it's not the correct way on which we can interpret the 𝗥𝗡𝗀𝗀𝗃 principle. It's not what actually the 𝗥𝗡𝗀𝗀𝗃 principle means. Because 𝗥𝗡𝗀𝗀𝗃 is a tool created in the context of state responsibility in general. If we speak responsibility, otherwise, of course, is a tool to disentangle conflict of norms in general. But in the context of state responsibility, is based on the supreme values of state consent, with which we, good or not, we are somehow limited by this element, under which two or more states can contract out from the general rules to establish their own system of responsibility. And for instance, they create a human rights court with their own system. Okay, that's perfectly fine. There is nothing wrong in that. But the 𝗥𝗡𝗀𝗀𝗃 argument is clearly not applicable if a state creates its own internal system of international responsibility. And actually, there are rules now in 𝗥𝗡𝗀𝗃, which says a state cannot use internal law to justify an internationally wrongful act. Of course, this is clear. But the problem is that when you apply the same concept to international organizations, because if you apply the same concept that is applicable to states, I would say that 𝗥𝗡𝗀𝗃𝗃 is only applicable when two international organizations or more or third states, they establish a regime that is based on international law, which is something that is separate from the institutional mechanisms created within one organization. So we can speak of 𝗥𝗡𝗀𝗃𝗃 if the European Union will finally join the European Court of Human Rights, for instance. However, I think that we cannot speak in terms of 𝗥𝗡𝗀𝗃𝗃 for all the partial, the inconsistent, all the mechanisms that are developed by the European Union itself do not actually deal with international responsibility. We speak sometimes of liability with this problem of the same before, of finding the perfect term. But it creates, I think, problems if the aim is to provide accountability for EU actions. So I would claim that it's difficult for me to consider an EU action for damages with so many differences with international responsibility as 𝗥𝗡𝗀𝗃𝗃𝗃 in relation to international responsibility. I would say that's something different. It's not an application of the 𝗥𝗡𝗀𝗃𝗃 argument. Then there is also the problem of the 𝗥𝗡𝗀𝗃𝗃, lex generalis. Often, I mean, it simply depends on the perspective, because for me, something is what is the general and what is the special, depending if you speak with an investment lawyer, with a trade lawyer, with a human rights lawyer, and so on, clearly. But in any case, for what is advanced by the European Commission is also, I feel, in contradiction with the claim that the European Union is a sui generis organization, because it created a legal system that is separate from international law on which the same lex specialis rules are based. So I'm a bit convoluted in this argument, but I think it makes sense. Because either you claim that the European Union can contract out from international law by the means of European Union law, so that you consider that European Union law is international law. Or otherwise, you claim that the EU legal system is not international law. I mean, you cannot have both. You cannot consider lex specialis only applies, lex specialis, lex generalis only applies within the same legal system. You speak in terms of regime, which makes things easier, but I mean, there is a lot of theoretical discussions on the capacity of the EU or other international organizations to develop their own legal system. And depending on which system you adopt, it changes completely the applications of the rules on responsibility. And even, I mean, the normative control, the exclusive competences, all the rules, all the models of how to attribute the conduct that are preferred by the European Union, by the European Commission, they are all based on these sui generis organizations and on the capacity to develop a legal system that is separate from international law. This, which is completely incoherent with the argument that you should apply lex specialis to avoid international responsibility. I hope it makes sense what I'm saying. That of course later I can develop, but I would like to also to move to the other discussion. So for the point on primary obligation, I really enjoy and I share completely, and it's actually even difficult, I feel, to try such a depth discussions on the capacity of the European Union and other organizations to be bound by human rights. Because often it's just put it there like, yes, customary international law applies to IOs, point, that's it, which is, I don't share this. I think I understand the difference you make between human rights commitment and obligations. And I would like to test also my understandings. Because you say that there is a difference between the content of a human rights obligation, if I understand, and the obligation as such. So, for instance, the right to life by the states with positive and negative obligation is an implementation of the value of human dignity, for instance. As much as criminal law cover a similar human rights content by criminalizing manslaughter. So commitment is linked with the values that are embedded in the human rights. The obligations is the actual obligations that is enacted. So, as you said, I agree that the law of international organizations did not develop a comparable set of primary rules to protect the same human rights content. And we cannot just apply a blunt analogy with the state, saying that all customary rules that applies to states also applies to international organizations without saying anything else. And I cannot agree more on this. But I didn't understand exactly your arguments. When you say, if I'm correct, that the European Union would be bound by human rights commitments. So understand what is the human rights. So at that point, I think I lost the argument. So under which source of law? I think I missed this step, if I understand correctly at some point. Then another important point I want to make on primary obligations. As I said, for what I said before, the European Union Charter fundamental rights cannot be considered as lex specialis for the same principle that I said before, and to say would be like saying that the Italian Constitution is not lex specialis in relation to international law if you apply these visions of the European law, which is the one that's actually fostered by the Commission, which also means that the European Union, but all other organizations cannot escape their interactions by passing institutional norms. And so another reference we can make is World Bank institutional policies, all these kind of rules, more or less binding, created by international organizations, which for me are nothing but unilateral acts from the perspective of international law. So this, from the perspective of international law, you can consider that international organizations, the European Union, is bounded by these norms developed by the organizations themselves, not because they are customary international law, but because they are unilateral act, with the issues of unilateral act, which means they can be retracted and so on. Because to establish customary law, then you need practice and opinio juris of states, of international organizations, and on the existence of norms that are specifically binding on international organizations, which of course is a very complex and different issues. don't know what you think about it and how you consider this argument. Then my last point, I have like 2 minutes on shared responsibility. Again, a wonderful discussions in your book. I also share that on the final pages of your book on this element of hope with the relational responsibility. And also I would like, I also look at shared responsibility as the perspective to adopt. Just a few remarks on I'm a bit more skeptical on how the guiding principle on shared responsibility are useful, because they make a bit, I don't completely agree with their definitions, especially by attempting to include causation and damage as the definition. So changing the definition of responsibility, which of course does not include causations and damage. And this creates a lot of problems which are frankly unnecessary, and it's overly complex. Also, there are issues that are also linked with damage and causation, on how they distinguish between single and multiple wrongful act, because there is no, under international law, there is no single wrongful act if more than one subject is involved, because then each actor is independently responsible. That's international responsibility, unless you want to change the definition of international responsibility. And if I read correctly your book, you consider shared responsibility only as instances of complicity, direct control and control, coercion, circumvention of obligation, which are all the issues under, all cataloged under Chapter 4 𝗏, which is responsibility in connection with another state. But I think it's also interesting to look at shared responsibility under Chapter 2, so under the rules of attribution, which arises in all those cases in which 2 or more subjects commits multiple wrongful acts in parallel. So under only a single conduct that is attributed to more than one subject, or 2 or more conduct, but that act in parallel, of course committing multiple wrongful acts, but they are connected by the other elements. And this is what I think we can be called co-perpetration, which is also something that I think is extremely interesting and important in the context of the European Union, in which so many actors are involved in all the case studies that you mentioned. But I think I should stop here. And of course, thank you again for inviting me. I'm really happy to go on with the discussion. Thank you.
Thank you so much, Lorenzo, for touching on so many different and interesting points. All the 3 issues that you have raised are really important, like specialists, the concept of primary obligations, the interpretation that Joyce makes in the book of shared responsibility, and our proposal to move forward through relational responsibility. I think that there is a lot of food for thought. Joyce, if you agree, I will give the floor to Sian now so that she can also give you more input and feedback. And after that, I will definitely give you back the floor so that you can at least start responding to their comments and questions. And then I think that we will have to organize a beer or a dinner sometime soon so that we can carry on with the discussion also in another setting. So thank you. And Sian, you have the floor.
Hello, and yes, thank you so much for the invitation. I'm very grateful for the opportunity. Congratulations, Joyce, again for the book. It's definitely a significant contribution to the study on integrated border management. But even beyond academically, congratulations for the fact that the Advocate General referred to your work in the recent opinion on the upcoming appeal judgment on WWS and others versus Frontex. I'm definitely joining you in keeping fingers crossed for a more satisfying outcome this time around. And I think the fact that your work was referred to, it shows a key strength of the work, that it's functional approach. But despite it's functional, but you never compromise on holding compassion in the fact that you start off from the position of those who are affected in order to then do this functional analysis. So that's definitely what I would bring up as the absolute strengths of this book. You rightly argue that the current EU human rights accountability system and mechanisms are failing to grapple with the reality of multiple actors in integrated border management and migration governance in general, and therefore calling for this clarification on who bears human rights responsibilities, who are those responsibilities to, under what circumstances are those responsibilities real, i.e. judiciable. And so in this discussion of multiple actors and functions that contribute to these ultimate outcomes of human rights abuses, such as reform, I've got some questions about the role of human rights compliance monitoring. So not in terms of the role like that contributes to being able to provide evidence like with Hamoudi, but more the specific roles of where an organization has a role of being there to ensure there's human rights compliance. So, for example, we've seen systemic failures with Frontex unable to comply with this obligation to, well, report serious incidents and then to withdraw from states where human rights abuses are being committed. The Frontex fundamental rights officer was even saying that this not acting on the obligation to withdraw is a kind of way of further protecting human rights, because it's better to be there, to be like the adult in the room, because if Frontex withdraws, then who knows, it will get so much worse. And at least with Frontex's presence, you know, and their role in providing training and equipment and personnel, that this is actually how you remedy this. So they're not incentivized to report to then trigger this withdrawal mechanism, because it's actually best if they do what they can to at least still stay situated. So that leads on to my first question of, do you think these failures that we see like this are because agencies like Frontex, like EUAA, are fundamentally compromised because they don't have a purely monitoring role? The fact that they're also actors that are involved in the reception and processing of international protection claims, that it's their monitoring functions are kind of doomed because of that. And then a further question is regarding the new pact. So instead of improving access to judicial review, instead there's this prioritization of just more monitoring. So it will be Frontex having monitoring role still, EUAA, and then also these the independent state monitoring bodies. And so when we're talking about this idea of relational responsibility, at what point is it also the case of that there are too many cooks, that we have multiple bodies that are apparently responsible for monitoring, but when they're all working at the same, monitoring the same things, and how do we identify faults if there's failures at monitoring? And so, does this show a broader issue with the idea of relational responsibility, that there's already so many actors, and maybe even if we were to employ more of an idea of relational responsibility, then just more actors keep getting thrown into the mix, and then it's like, you know, trying to keep up. Or does this just speak to actually what's more core, that it's about when you have multiple actors, clarifying what the roles are, what the actual, so for example, obligation to do human rights monitoring compliance, that should be clarified what that means. Who is that responsibility to? What are the circumstances of there being a failure or not? Okay, so, and then I also wanted to say how I really appreciate that you brought, in your book, you brought attention to often overlooked issues, such as how restrictive visa regimes block safe routes to protection, and also how even where they exist in a discretionary manner, like the humanitarian visa in the visa code, there's also these very practical inadequacies of the route. The fact that there's the applications themselves require certain documents, require certain categories of information that for someone who's fleeing to seek safety, they're not in a position to be able to provide that kind of information. But also how when you're talking about that, you're highlighting this inconsistency between its discretionary nature of the humanitarian visa, and then also having these references to international obligations. How do they interact? At what point does the obligation give way to discretion? And I think this speaks to a broader problem that definitely I see with looking at the new pact, this very loose reference to international obligations and fundamental rights protection, despite there being very serious concerns about the very design of procedures in the new pact, that you can't just, oh, well, you throw in a recital somewhere that, of course, everything must be done in compliance with fundamental rights protection, but then the very thing that the provision is telling states to do is the thing that it poses the risk. And it's this worry about this language just being thrown in as window dressing. And okay, to expand further from this critique of looking at the failures of humanitarian visas, what does that really mean for non-refoulement? And I am aware this, I'm kind of I'm taking it out there a bit here. But is there anything to be said for the declaratory nature of refugee status, as it is confirmed in the Qualification Directive? Therefore, maybe that then triggers Article 18 of the Charter. And could this result in there being indeed a positive obligation to accept resettlement applications for it not to be discretionary, or even further, a positive obligation to ensure safe routes? But of course, international refugee law doesn't guarantee this right to be resettled in a specific state. It doesn't impose obligations on states to offer resettlement either. But it is, as you highlight, it's undeniable that it's the lack of safe routes via visas or resettlement that results in people pursuing dangerous routes, either to get to a physical border or because of carrier sanctions, the need to use some level of deceit in order to acquire a visa, which, for example, if it's a visitor visa, you're using deceit in the sense that the purpose of the visa is not indeed for visiting, it's for arriving into the state to then make your claim for international protection. So my last question is, so given the declaratory nature of refugee status, plus this obligation to ensure practical, effective access to procedures, and where hopefully we can get more word from the courts about what are the actual bounds of non-refoulement, do you see any legal or normative pathway that could gradually transform resettlement or humanitarian visas away from a discretionary act to actually more of an enforceable right? And I'll leave it there. Thank you.
Thank you so much, Sian. You also raised a lot of important questions and issues, and I personally really liked the way that you put the functional approach of Joyce's book to the testing, in the sense that you actually put it to work in relation to the new potential developments before the Court of Justice of the European Union, but at the same time you referred in your questions and comments to the new pact on migration and asylum, and on the relevant framework for the status of refugees. And I think that you also highlighted the transformative potential of the book, which is actually a very interesting aspect. And I'm sure that Joyce is beyond thrilled to have the opportunity to reply to the questions that Lorenzo has raised, and as well as to the ones that Sian has shared with us now. I will give you, if you agree, 10 to 15 minutes to reply to those questions, and then we can gather a little bit of additional comments and questions from the audience, okay?
All right. Thank you so much. It's a nerdy thing to say, but I'm so thrilled to be able to engage with people that know what I'm talking about. Very often I get silent because it's just too much in one go, I think. I'm going to do it a little bit weirdly, and I'm going to start with Sian's questions, especially the last one I just very much enjoyed because it's part of my interests now at the moment. What I think you're hinting at, but not saying out loud, is the transformative potential of EU governance within the human rights space, within the IBM space, in terms of what that means for human rights law more generally. To be honest, as you were speaking, the right to safe routes, I think that could be just a publication in and of itself, where, you know, so maybe as a precursor, one of my biggest frustrations within the specific field of integrated border management these days is that we're constantly just reduced to this senseless binary of in-out. Are you worthy to come in? Shall we give you protection or not? As though there's this capacity to, you know, artificially close or open borders. But the questions that are inherent to the IBM debate are so much richer than that. And I think by reformulating the narrative to something about right to safe routes, I think that would already be doing a ton of work in this space in terms of shifting the focus to something that's actually going to make sense. So I'm going to start with your last question. And it seems to me like what you were saying is there space to kind of balance out this, on the one hand, discretionary nature of what the EU can do within the context of the visa regime, and on the other hand, the obligatory nature of international human rights law specifically applied here. And I think what I'll do is my answer to that is manifold, but I'll focus on one specific project I'm working on right now, which is deliberative discourse in developing the EU's human rights the EU's human rights regime. And what I've noticed as I was going through this book is that one of the questions that's inherent to human rights is that it be representative of larger publics, right? Not just the select few, not the ones designing. It's supposed to be providing protection to all, including vulnerable categories of individuals. And what I notice is that if we've got a blank slate with how we look at human rights responsibility of EU entities, we also must take a step back and be courageous enough to kind of go and question who is designing the human rights responsibility regime, but also human rights regime of the EU more generally. And I know that's a bit of a long-winded way to get to the answer, but what I think is crucial here is, yes, I think there is a way forward in developing that more enforceable, definitive lack of discretion in terms of developing the visa regime. But I think that requires a bigger step backwards in terms of reshaping how EU legislation is done. And so I'm thinking of the work by Ayola Solanke, I'm thinking of the work by 𝗥𝗶𝗴𝗵𝘁𝘀, both of whom kind of investigate what happens behind the scenes and who's being represented at EU institutions specifically, and the European Commission even more specifically, and whether that truly is a reflection of the different publics that populate Europe, and whether it is representative of the general public's understanding and perspective on how to develop visa regimes. Because I think, again, I was getting a bit of pushback by a commentator in one of these book talks who was saying, Joyce, nobody wants the migrants. Nobody wants the migrants. And I was a bit frustrated by that sentence, because who is the nobody in that? And what are the questions that this group of people is being asked with respect to border management? Because again, if the questions you're being asked is, oh, migrants are coming in and stealing your jobs and murdering your friends and all of that, yes, of course, people would want closed borders. But if your question is, do you want individuals to come in or be sent back and tortured in Libyan, detention centers, I think, we might see a different answer emerge. And because of your mention of the right to safe routes, I'm kind of wondering if you postulated the question as such: should individuals that are on the move be entitled to a right to safe routes? Your answer from the more general public would again not be, I think, what one would expect based on populist discourses that we're seeing across Europe and across the globe more generally. And Andrew Getty said the European University Institute has recently concluded a study that kind of comes to this point, that the actual democratic consensus on questions of migration is a lot more nuanced than what populist parties would like you to believe. And so my long-winded answer to that first question is, yes, I think there's way forwards, but we would have to think about who is designing the visa code and whether that is truly a representation of not just the select few, but a representation of the different publics, which is, again, the direction of 𝗥𝗶𝗴𝗵𝘁𝘀's work. Is it really a reflection of the diverse publics that make up Europe and their sentiments, their democratically infused sentiments about migration, borders, and asylum? So that would be one. In terms of too many cooks in the kitchen with respect to monitoring, that's precisely the point of relationality. And I'll give you two examples. At some point, I wrote a paper about 𝗥𝗶𝗴𝗵𝘁𝘀, which collaborates with Frontex and thus, by virtue thereof, also with the member states. And 𝗥𝗶𝗴𝗵𝘁𝘀 is a US-based commercial satellite imaging company. And so it allows for satellite images to be transferred to Frontex, which can then monitor in more real time and closer to, if not in or above, third state territories, because it's above the airspace governed by international law. It can monitor movements of individuals, right? And so what you see there is that even though, you know, the consequence of that type of data sharing between these different entities may very well be that you're not only facilitating push and pullbacks, but you're also facilitating situations in which the Libyan Coast Guard, for instance, can keep people from even leaving Libya. Even though the consequence is the same, the harm is the same, it becomes even more difficult, because what can you really do in that instance? Because if the satellite company sends on data points, it hasn't really done anything that would be liable to generate liability in the United States, because it's not an egregious human rights violation. All it's doing is just sending on data. If you try to apply that logic, one could say that maybe Frontex could be held legally responsible for data protection violations, but there too, it seems unlikely that that would, you know, sufficiently carry the weight of the violation, and whether it would even be possible under the data processing and data protection rules that we have in the European Union. Same thing with the member states. So what you see is the more cooks you get in this monitoring role, the less likely it becomes that you're going to find any actor that will be sufficiently responsible for the harm to be able to hold responsible. And a second example would be the increasing use of AI. So we talk a lot about AI, and I'm by no means an expert, but what I've understood from experts in the field is that just the supply chain of how different AI are constructed for different purposes in different policy domains leads to a situation in which the manufacturer itself doesn't even know how the AI is constructed or how the algorithms are mapped and conditioned, much less who should be held responsible if there is some flawed outcome through the use of that AI in that particular setting. So what you see is that cookie crumbling, right? We don't even know who or what is responsible anymore, let alone who should be held legally responsible under the different interacting regimes. So in that sense, it doesn't make any sense anymore to apply this actor-centric, state-centric, atomistic way of thinking about responsibility. So the relational approach would be in favor of simply akin to supply chain regulation, right? You look at the totality of actors, and everybody, all actors can, to different degrees, be held legally responsible, and how that division of responsibility occurs behind the scenes would not be a question for the actual applicant once a harm or a violation has been established. That would be something for the actors internally to figure out. And again, this is not based on me just, you know, making up things. This is based on the joint and several liability regime, which underpins domestic tort law in a number of regimes, but more specifically, the joint and several liability regime that underpins Europol's underpinned Europol's interaction with member states, where it was explicitly said that in order to avoid these types of questions of attribution and trying to figure out who did what in very secret, covert types of setups, it's easier and better in terms of the right to an effective remedy to simply allow for the applicant to be able to show that the harm has occurred and then for the complicit partners to just figure it out behind the scenes for themselves. We wrote a paper on this too, and I mean, there's still issues with that regime, but at least it's more relational in that the individual is no longer burdened with the obligation to try under different regimes, through different procedures in different jurisdictions, to try to hold any one of these actors legally responsible. So yeah, that would be the point of relationality. And then are the failures due to the fact that Frontex is fundamentally, or these agencies are fundamentally compromised, and like due to the fact that they're not exclusively monitoring? That's a good question. But it's a different question. That's why I was talking about the different actors, or the different authors rather, working in this field. I think there's ways of looking at this. You can look at the policy, you can look at the entity. What I do is look at the regime, which is a preceding step, right? So yes, I agree that definitely the fact that, I mean, if you look at the history of Frontex, it went from purportedly mainly monitoring to something that is completely different in a field where there's just complete absence of understanding of how that relates to human rights responsibility. So I agree the fact that we've moved on from just monitoring to something completely different creates a space in which they can do pretty much whatever. And there's no adjoining or concomitant understanding of what that would mean in terms of responsibility. And I thought it was really funny that you were saying that is it not better to withdraw because, you know, or that this is what the fundamental rights officer said. And I have 2 points on this. I don't understand how we can't just get to the deployment of Frontex in a way that is human rights compliant. I don't know why there's this absolute resistance to consider different ways of working through and with Frontex in a way that would be fundamental rights compliant. Because I do understand that if you're trying to create an area of freedom, security, and justice, according to the very constitutional ideas underpinning the European Union, that maybe you want to collaborate within the context of external border management. However, there seems to be this assumption that as soon as you collaborate through Frontex, it has to be this way and no other way, as there's no room to think through that diligently in a human rights compliant way. So I already object with the idea, the binary, that it would be either withdraw or we keep Frontex. 2, if you withdraw, the idea is that it would somehow be worse. But what we have now is, because they're there, it creates a situation, and that's the second issue of the human rights responsibility gap, where the EU member state itself also escapes responsibility because of the fact that Frontex is there. So if you take Frontex out of the equation, it's very simple. Then it's just the Greek border and coast guard, for instance. Then you don't have that question of transferred powers and, oh, who did what and who do we attribute to, tra-la-la. No, you just have the Greek border and coast guard without the hot potato being passed on to different entities. So I disagree with the fundamental rights officer on this particular point. But that said, I don't think it should necessarily withdraw. I think Frontex should just be capable of developing standards and practices that are human rights compliant. So I hope that kind of answers the questions that you had. And then Lorenzo, thank you so much for the questions. I think we'll have to settle on disagreeing a little bit on what we understand under the Lex Specialis rule. And because you were talking about how you understand it, I went back to the audio articles and the commentaries to it because I knew I'd highlighted what they had said. And I think maybe as a premise or a preface to this, I think you might see that it's doing more work in the book than I intended to do, because I don't intend to have the Lex Specialis do much except for, indeed, as you said, connect it. But there's no normative orientation there. There's no assumption as to what it means or what it should mean or what it could mean. So for me, it was just a way of seeing, okay, can we answer this responsibility question completely blind to the fact that different institutions have contributed to the use and the practice of the rules embedded in the ARIO? And so because the answer was like, we can't really ignore it, I decided to take it on board. When I look at the Lex Specialis, I think what I was struck by is not that it allows you to contract out, and I'd have to double check with state responsibility, which is a whole different ballgame to begin with, but at least in the ARIO, it doesn't say contract out, it says supplement and or contract out. And so for me, when I look at the Lex Specialis, for me, what it's doing, what the EU's legal regime is doing, is supplementing. And in certain areas, of course, replacing, but not really replacing, because it's just adding its flavor to it, if that makes sense, rather than really saying we're disavowing. And that's why I said that I adopt a functional lens, because despite the fact that different terminologies are used to point to, for example, unlawful conduct for me is the exact same thing as, or points to the exact same thing as violating an EU obligation. So you're both looking at primary norms, to use international law speak. You're looking at the right to life, you're looking at the prohibition of 𝗥𝗶𝗴𝗵𝘁𝘀 or whatever, and you're saying, okay, did you violate that or not? And of course, there's different qualifiers. So for example, under the action for damages, the European Union's legal framework requires that that unlawful conduct be sufficiently serious. So it complements this functional understanding of the violation, right? And so I think I'm a little looser about what lex specialis means. And I mean, again, I don't really have any hard points on that except for that. So I had three smaller remarks in response to that set of questions. One of the things that I run into when I'm talking about EU responsibility and the EU more generally in both classrooms with colleagues, etc., is that the EU gets aggregated into one static thing. And this is where I fundamentally disagree, because it's not one static thing. It's got different institutions, and those institutions are populated by so many different entities. I mean, the European Commission alone has so many different DGs that make up the Commission. Then behind those infrastructures of the Commission, you then have all these different people working on all these different tasks. So what I saw through going through these different regimes is that different EU institutions were using different EU entities were using different ways of looking at lex specialis, of attribution, causation, and so forth. And what I noticed, very similar to the way the EU developed over time, is that certain individuals, certain actors would be advocates of seeing, you know, the lex specialis as a set of self-standing rules that allows the EU to contract out of and thus be an autonomous, self-standing entity, whereas other entities would approach it differently. And you just see that this fluctuates through different institutions, bodies, offices, and agencies, and over time. So I think that's why, again, I don't try not to let the lex specialis do more work in the book than it's intended. And then finally, I think maybe on a general point, why I don't think it does more work than it does in the book is because for me, the chapeau has always been international law, right? Specifically within the EU, there's this idea that the European Union cannot place EU member states, and I mean this is a general principle of international law too, but it cannot place its member states in a situation where they can no longer abide by their own treaty obligations, right? So regardless of how you as a scholar, not you specifically, but other EU scholars, for example, would decipher or see or analyze the European Union, it remains within this shell of international law where it can't place EU member states in a situation where they can no longer abide by their treaty obligations, which then in turn is then captured again by the equivalent protection doctrine spelled out in the Bosphorus case by the Strasbourg court. So I think that's again why I let it do less work, at least in my head and in the book. So that would be one. With respect to primary obligations, I love that you said content versus obligation, because I don't think you want to know how many years, literally.
Joyce, I'm so sorry to interrupt you.
I'm going too long.
Is it possible to keep it within 2 minutes so that I can also open the floor to the audience? Is that okay with you?
Absolutely. I'm so sorry.
Thank you so much. No, that's okay. That's okay. It's a fascinating discussion. I'm sorry to interrupt.
So your question was, what source is the EU bound by? The Charter of Fundamental Rights, and the Charter of Fundamental Rights in various provisions within the Charter, but also outside of the Charter, says explicitly that it is inspired by international law and the common constitutional traditions of the EU member states. And therefore, your source is, and again, the court will adopt different stances depending on who's on the bench and who the Advocate General is, but some will be more in favor of an autonomous understanding of what the Charter means, and some will be more inclined to bring in international law. 𝗥𝗶𝗴𝗵𝘁𝘀, AG 𝗥𝗶𝗴, I think would be more inclined to bring in international law, whereas others may be less inclined to do that. And then with respect to shared responsibility, one of the questions that you asked is, what does the work of the guiding principles really do? I thought it was helpful that they made the distinction between concurrent, cumulative, and cooperative conduct, and I actually offered that to the Court of Justice because I think those are different ways of looking at shared responsibility that might be helpful to the Court of Justice in trying to decipher these Frontex situations. But where I think it still falls short a little bit specifically is with respect to these requirements under shared responsibility of the ARIO. So I wasn't looking at 𝗥𝗶𝗴𝗵𝘁𝘀 at all, but under the ARIO, we have the issues with attribution, which I spell out in the book. We have the issues with causation, which I spell out in the book. But more specifically, I was looking for more help on what the opposability criterion means. So I don't want international law of international organizations to spell out what's supposed to be done for each and every single IO within the context of human rights. But more generally, I was waiting for more clarity on what opposability would mean. Does it mean the commitment? Does it mean the obligation? And that distinction is very crucial if you're going to try to have a more overarching theory of responsibility between different actors. Okay, thank you. I'm so sorry for talking too long.
No, it's okay, don't worry. And Lorenzo, I know that you want the floor back, but you are not going to have it. So I'm going to open the floor to the audience. Thank you so much for listening to the presentation and then to the discussion. Do you have questions? We will collect a few of them and then I will give the floor to Joyce for a final round of replays, okay? Yes, Professor Martinico.
Thanks indeed. Let me break the ice, as I'm sure that in the audience there are experts. I really enjoyed the discussion. I really enjoyed the book. Congratulations, Joyce. I think it's a gem. You crafted the gem, and I think that this will be a seminar work. I'm sure about that. I have the question about the very first part of the book, because in the first part of the book you refer to the critical perspective on human rights advanced by the third world approaches to international law. So I mean, you briefly acknowledged trial critiques, but ultimately reaffirmed in the book human rights as the normative basis of your analysis, if I'm not wrong. So could you please elaborate, I mean, how your proposed framework accounts for the structural inequalities in global governance that trade scholars emphasize? And do you see a risk of reinforcing a Eurocentric model of legality in this respect? And that's my question. Then I have really out of curiosity, I'm interested if in exploring whether you see any role for national courts, because I know that there have been important works by Reinisch, for instance, about the possibility of challenging the legality of international acts before national courts, depending on the jurisdiction, of course. I don't know if this can be a solution given the difficulties in accessing EU-level remedies. Thank you so much again.
So thank you. Thank you, Giuseppe. We also have a question in the chat that has been written down by Camilla. She has some issues with her mic. So Joyce, would you like to read it or do you want me to read it out loud?
Whatever you want, whatever is customary.
What is customary, Professor Martinico?
I would say, first of all, they call me Giuseppe. Then they will say that Joyce can read it, okay, because it's important for the recording. Thank you so much.
Okay, so the question concerns monitoring for compliance with fundamental rights protection under the new pact. I forgot to mention this actually. But in addition to the European Ombudsperson's growing role to tackle the accountability gaps, especially in the case of Frontex and the EU Asylum Agency, do you think that the EU Fundamental Rights Agency could jump in the discussion and make the most of its competence, first and foremost related to knowledge input with periodic reports? What role could Olaf play? Would this change interagency balances? Okay.
Perfect, thank you.
Would you like me to start or do we wait for additional questions?
Do we have additional questions? Don't be shy. No? Okay, then you can start with these two, and then we will see if there is any other question left.
Okay, so thank you so much for the questions. Mindful of the time, I'll jump right in. I'm going to do a small shout out to one of my favorite colleagues at the moment, Giulia Raimondo, who is always very inspiring whenever I talk to her. And she very frequently talks about how you cannot use the master's tools to tackle the master's house, right? So, and that's the type of thinking that goes into 𝗘𝗨'𝘀 scholarship as I have read it. Can we really use tools of human rights law to be able to deconstruct the structural inequalities that are there? And then I read Nadia Murad's account of the genocide that she witnessed, experienced, etc. And I was struck by the fact that she does come back to human rights as that normative bedrock. And I see the people at the Center for Human Rights and Global Justice, César Rodríguez Garavito specifically, pointing to the fact that we should just stop with this end of endism. We've been talking about the end of human rights for so long, for over a decade, but it's not ending, it's not going away. And I think it's because it's that normative underpinning that is resilient and that is intended to do good work. And there, that distinction needs to be made between the normative bedrock on the one hand and the institutions and practices, etc., that we have on the other hand, which might contribute or do contribute to structural inequalities. And to go to your question specifically, is there a risk of reinforcing that Eurocentrist Western thinking within the context of human rights law? I think this is precisely why I was struck with this deliberative discourse paper. Who is designing the responsibility regime? Who is responsible for understanding and designing what EU entities should be bound by in terms of human rights? Who is human rights protecting? So, small anecdote very quickly. Somebody asked me within the context of report for the European Parliament that we were asked to deliver on making human rights clauses more effective in EU trade agreements. And I pushed back and I asked, what does that mean? What does it mean to make them more effective? For who? By who? In front of what courts? On the basis of what sources? Just make them more effective, they said. And I was a bit frustrated because are we making them more effective on the basis of the Charter, which would be very problematic because that could account for or result in normative imperialism? Or are we, reverting back to more international sources such as the ICCPR, the Universal Declaration of Human Rights? And then again, what kind of procedures are we putting in place? Who can, invoke responsibility of which actors against which harms? And so if you have a diverse public designing these regimes, you run less of a risk of it being a Eurocentric design. And I think that's the next step of questions that will need to be answered, at least within the context of how the EU's human rights regime is constructed. Then in terms of the role of national courts, this is one of the favorites of EU scholars. They're always asking me, but Joyce, the preliminary reference procedure, can't we turn to that? It is the pinnacle of EU human rights or EU protection tout court, right? And I agree that for a lot of huge questions of EU law, the preliminary reference procedure is the way to go. But it all depends on what the question is that you're asking. If you're trying to seek remedies for individuals, what the preliminary reference procedure could do is have a national court ask a question to the Court of Justice in terms of interpretation of how we divvy up, so to speak, the responsibility in joint operations between EU member states and EU entities. But what that results in is an interpretation that the Court of Justice will give, and what the domestic court would be able to do is solely account, based on that interpretation, for national responsibility. And so it doesn't really fix the problem of EU entity responsibility. And so that you could take in turn to the next procedure, to an action for damages. But what that means is that we're prolonging access to an effective remedy, at least in terms of reparations for individuals whose rights have been harmed by EU entities. So yes, it could do a lot of interpretive work, but essentially the duration of your procedures extends tremendously. And I don't know whether that's really in line. Well, I mean, I have questions about whether that's in line with the right to an effective remedy, which requires that the right to an effective remedy be obtained within a reasonable amount of time. So I think there, within the context of joint operations, domestic courts have a more limited role to play. And then the final question with respect to these different entities, I mean, I'll be completely transparent here. Camilla and I had a conversation very similar to this a couple of days ago, and she knows that I think the role of EU entities beyond the institutions that are involved is huge because the European Ombudsperson and Olaf were instrumental in the Hamoudi case in terms of bringing evidence to the table that allowed for a prima facie case of evidence to be developed by the applicant. And I think there's much more scope for these agencies to, or these entities to be working together and to be helping. Again, this goes to the point of Frontex being able to be an agency that is capable of operating, albeit within fundamental rights standards. And I think other EU entities can contribute to elevating that level of, or that standard of protection. However, the same point goes. It depends on who is populating those entities. If it's just the select few that adopt a very Eurocentric perspective, I think you're going to run into the same problems as you do with the EU legislator developing what Sian was referring to, these very practically nonsensical pieces of legislation that require third country nationals to fill in documents that they simply cannot fill in for the purposes of obtaining a visa. So it really depends on who's populating the different agencies, entities, bodies, offices in terms of advancing a standard of protection that would be effective.
Thank you so much, Joyce. I don't know if we have other questions or comments. Okay, so if that's not the case, I will thank you again for your presentation, for your amazing work, for deciding to putting victim at the center of your analysis and moving backwards in order to establish accountability and try to close the current gap. I'm also grateful to the discussants. I think that both Lorenzo and Sian did an amazing job at highlighting different parts of your book and of your work and providing very valuable and deep insight into your book. So thank you again also to Giuseppe and Giacomo for organizing this STAL seminar. It has been extremely interesting also for me, and I hope as well for the people who have attended it. So without further ado, I will declare this seminar officially over. And we look very much forward to welcoming you in Pisa, possibly in September. It would be really a pleasure to host you and to organize another event with our PhD students as well as with our master students. I think that they will be extremely interested in learning more about your work. So you have a pending invitation whenever you want, and we will get in touch with you after the summer break to organize it.
Thank you so